nothing left to say. What the hell was going on? What the hell did I do wrong? I'm picking up the pieces to a puzzle that'll lead me to you. What can I do? Oh, I'm bending backwards, only two words left on my mind. Well, I'm bending backwards, only two words left on my mind. Someone in there, or further away. And you know there's nothing in the world that could make me go back to you someday. Ooh. What the hell was going on? What the hell did I do wrong? I'm picking up the pieces to a puzzle that'll lead me to you, and then I want to go. Oh, I'm bending backwards, on two words left.
Hey everyone, Greg Staley here from Diverge Media. I'm doing a quick one on the article I released today because it is a lot to take in. Just from a title, it may not entice you to click, but I put a lot of good information in there, so I wanted to share that out so you understand what I did. So without further ado, as soon as my producer's done feeding my baby, we'll pull up the article here today. So the article I wrote today was Your Rights Under the Reopening Ontario Act. Now, I start with saying that the Reopening Ontario Act and others like it throughout the country have given Canadians the ostensible view that their rights are on hold, that the emergency powers supersede their rights. This couldn't be further from the truth, but we understand how the draconian actions that we've been beholden to would cause you to question the aforementioned statement. Things become especially obscure when we witness police enforcement of these unjustified measures. They lend credibility where it otherwise might not exist. Now, going right into the Reopening Act legislation, taken from here, this is the Reopening Act legislation. So all linked in the article here today. But basically, they say in that Reopening Act, in fact, I'll just read it from here. Whoa. Is this the explanatory notes? So enforcement provisions are included to provide the courts orders to restrain contraventions to provide for offenses. Those provisions are based on the provisions of the Emergency Management and Civil Protection Act. So when you go into the Emergency Management and Civil Protection Act, it says that the orders made under Section 7.02 or 7.1 of the Emergency Management and Civil Protection Act that have not been revoked as of the day of this subsection comes into force are continued as valid and effective orders. So essentially, they rolled it into the Bill 195 Reopening Ontario Act, but these sections still apply. Now, these sections reference what? Went on Ontario.ca, cross-referenced it to make sure I had it right, but basically, the Emergency Management and Civil Protections Act 7.02, the purpose of making orders under this section is to promote the public good by promoting the health, safety, and welfare of the people of Ontario in times of declared emergencies in a manner that is subject to the Canadian Charter of Rights and Freedoms. So the Reopening Act of Ontario is subject to the, sorry, I'm getting distracted by all the noise in the background here. It is subject to the Canadian Charter of Rights and Freedoms. This means that any measures that violate any Ontario Charter rights are subject to reasonable limits that can be demonstrably justified in a free and democratic society. That is Section 1 of the Charter of Rights and Freedoms. Direct quote of it is, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So I read from, did a little research, found an article from McCarthy and Tetrolt, the number 2 law firm in all of Canada, according to a 2018 Acrita survey. They had this to say in their article titled COVID-19 Limits on Government Emergency Powers. Quote, charter rights are not absolute as noted above. Section 1 provides that they are guaranteed subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. If a government measure in response to COVID-19 limits a charter right, and if that measure, keyword if, now listen closely on this, is where it's this is the drive the point home, and if the measure is challenged in court, then the government will be required to show that the limit is justified. So it has to be challenged in court. So essentially they can pass something if it goes through the proper channels and it gets passed and it limits your rights, they're able to do so, and then it needs to be challenged in court, and then they would be required to show that the limit is justified. This is why this is an important article today. In the case of McDonald Inc. versus Canada, Attorney General, the judge had this to say: Section 1 inquiry is by its very nature, that's Section 1, reasonably demonstrably justified in a free and democratic society, that's what it's referring to, is by its very nature a fact-specific inquiry in determining whether the objective of the law is sufficiently important to be capable of overriding a guaranteed right. The court must examine the actual objective of the law. In determining proportionality, it must determine the actual connection between the objective and what the law will in fact achieve, the actual degree to which it impairs the right, and whether the actual benefit which the law is calculated to achieve outweighs the actual seriousness of the limitation of the right. So, in short, this is in a reference to the Oakes proportionality test. When you take away somebody's charter rights, they need to be demonstrably justified. And what we have here in Canada is something called the Oakes proportionality test. That is a 2-part test, and we'll go through that quickly now. So the following is from A Brief Introduction to Law in Canada by John Fairley and Philip Swarton. I have some legal textbooks from my time studying to be a paralegal, didn't graduate. But anyways, quote, the court developed a general 2-part test, now known as the Oakes test, to determine whether the law infringes the charter is a reasonable limit on one's charter rights. The onus is on the Crown to show a balance of probabilities or preponderance of probability that the limit is a reasonable one by proving, 1, that it relates to an important social objective. They'll say it does. It relates to slowing the spread of COVID. And 2, that it is proportionate response to the problem. Specifically, the Crown must prove the following. Number 1, they must prove important social objective, pressing and substantial concern. Now, this one could be argued in court, but I imagine most judges would probably uphold it based on the information out there. You would have a harder time proving this portion of the Oakes proportionality test. The government's objective is creating the law must be shown to be of sufficient importance to warrant overriding a charter right. The standard for this part of the test is high, but it's often met by government in charter cases. So if it was signed off, they're likely going to say this was met. Now, this is where it gets, I don't think it meets this level of the Oakes proportionality test. And again, this is my opinion. I'm not legally trained, and this advice cannot be, we're not going to be responsible if you decide to act on the advice in this article and you're unsuccessful. This is merely research. We try to well research it, try to give lots of sources directly from textbooks, etc. But again, not legally trained. 2, second part of the Oakes proportionality test, 2, proportionality. If the objective is found to be sufficiently important, the government must show that the means used are reasonable and a fair way to achieve its legislative objective. So is it reasonable to shut down small business while big box business stays open? Is it reasonable to limit the, on and on the list goes. We can think of a number of things that, is it a reasonable and fair way to achieve its legislative objective? We now have people advocating for Walmart and Costco not to be able to sell certain things rather than open small business on these type of grounds, I would imagine. Now, that's not a solution either. The solution is to open up business and allow them to go ahead safely and have a plan to do that safely and give a fair and equal ground to people. So section 1, rational connection. The measures that impair the charter right must be designed to achieve the government's objective. In other words, the measures must be rationally connected to the objective. So there's probably a lot that could fall short here. That are they rationally connected to the objective? They must not be arbitrary. Well, you would say the arbitrary closure of small businesses, etc., when other businesses are open. Now, what they're doing is maybe try to get around this is actually trying to limit what big box stores sell as well, which again is not the solution. Unfair or based on irrational considerations. Minimal impairment. 2. If a rational connection exists, the court will then examine the degree to which the measures impair the right of freedom. The right should be impaired as little as possible. So completely shutting down a store for weeks on end for the second time within a year, I'm going to say that's not as little impairment as possible. I would say, in fact, that there is much better ways to go about reaching your measures, even if we don't agree with what those measures are. There's better ways to go about them. So, and 3, proportionate effect. The effects of the measure that limit the right or freedom must be proportionate to the objective identified. And this is another one that I don't think they would be able to pass. Recently, in our Sweden article, we talked about a CBC article that came out. It was a CBC investigation piece that came out January 2020, right before we had COVID come to our shores here in Canada. And in that article, they talked on average, I believe it was 181 days that hospitals were over the 100% capacity limit. Now, this is a regular occurrence for Canadian hospitals, and especially the ones in, you would say, high COVID regions, your Peel region, your Toronto regions, etc. Now, if we're going to have a fair comparison on that, they would have to compare previous flu years, previous overcapacity numbers, and then say, well, why is it suddenly justified today when previous years we were over capacity too, and we figured it out, etc. So these are the things to keep in mind for the Oakes proportionality test. Now, if you don't have the money to get the textbook, I highly recommend it. I think it goes for $50 right now, a brief introduction to Canada. You can also get Can Lee's general summary on the Oakes proportionality test here. Now, recently, a gym owner in New York was able to reopen his gym at 100% capacity when the judge ruled in his favor. The gym's lawyer, Paul Cambria, this is in New York, the United States, argued the capacity limit was arbitrary and capricious. So think of the Oakes proportionality test. You can't arbitrarily pick and choose. Why is it okay for some? So they were allowed to open at 100% capacity, but must follow other safety protocols. Now, that was all they sought and went to court on, was the ability to be open at a 100% capacity. Now, if they challenged on other things, they might have won, but it's sometimes better in court to keep it simple and go after one portion of something that you feel that is viewed as a violation of rights. It's sometimes easier to get it done and push through that way rather than go through on a bunch of things. So we basically say, I believe it is in the best interest of Canadians not to wait on one lawyer or a few lawyers to try to reverse these decisions, but to crowdfund their own challenges. More eggs in the justice basket presents more opportunities for wins. If you're thinking of taking a legal action against a measure that is against the charter, you should know most lawyers will take on legitimate cases so long as you can pay the retainer and fees. So that's where the crowdfunding comes in. In the case of masking, if you were looking at taking something like masking to court, you may find the Ontario Nursing Association court ruling from 2018, where they struck down St. Michael's vaccine or mask policy, twice helpful. The arbitrator had this to say in that case. After reviewing extensive expert evidence submitted by both ONA, the Ontario Nursing Association, and St. Michael's Hospital, which was the lead case for TAHSN Tazen Group, arbitrator William Kaplan, in his September 6th decision, found that St. Michael's VOM policy is illogical and makes no sense and is the exact opposite of being reasonable. This is something that you would say, if there hasn't been another court ruling, could be a precedent going forward. Influenza particles are larger than coronavirus particles, as you can find in science textbooks. If you start looking through the types of viruses, it's been proven that it's about 120, I believe, nanoparticles. We covered an article on it a while back where we touched on that. This is why this is maybe worth bringing up if you're thinking about challenging on a mask policy. Now, this isn't legal advice. This is simply an opinion piece. In addition, arbitrator Hayes in the 2015 court ruling, so they won in 2015 and 2018, and the other arbitrator Hayes, had this to say. Arbitrator struck down the same type of policy in an arbitration that included other Ontario hospitals across the province, with Sault Area Hospital or Sioux Area Hospital as the lead case. Hayes found there was scant evidence that forcing nurses to use masks reduced the transmission of influenza to patients. So go through the charter rights, all linked here. We also linked the Charter of Rights and Freedoms in there. But You have the right of freedom of thought, belief, opinion, expression, including freedom of the press, other communication, freedom of peaceful assembly, and freedom of association. You also have freedom of mobility rights to remain in or leave in Canada. Status of a permanent resident has the right to move, take up residence in other provinces. We have the legal right. Everyone has the right to now arbitrary closures of businesses. This is your legal rights. Everyone has the right to life, liberty, and security of person, and the right to not be deprived thereof, except in accordance with the principles of fundamental justice. So, if the Oakes proportionality test, you have the right to liberty and security. If you're a business owner and you're not able to make ends meet, and they're telling you you have to take loans and all sorts of things that may or may not make ends meet anyways, it's high time that people begin to try to challenge these measures in court. Crowdfund it. If you're interested, reach out to Diverge Media. If you're serious, you hooked up with a lawyer, you started the process, we will have you on and we will try to promote your court challenge. I believe more and more people need to begin challenging these measures. The Oakes proportionality test is the test that needs to be met. And examples of charter-related cases, we have a link in here that gives 37 charter-related case challenges. That's maybe going to be a useful tool for you as well. But again, these are my opinions. There's more to come on this. We're going to explore the general ideas around it. But it's a very complicated thing. I'm not legally trained, so I'm being careful as to not say too much. They may have a stronger constitution than we do, though. Maybe. Basically, from what I've read, Sam, it is hard to challenge these things in court. The government holds a strong position based off the hop. But again, they need to meet the Oakes proportionality test. And if we don't have tons of people challenging it, how do we know if it's going to meet it? And it's not, don't challenge on 100 different things, challenge on one. In the case of New York, we had the challenge, and he challenged just on the arbitrary and capricious manner in which he was only allowed to operate at 25%. Now, how's that fair when source of transmission is not coming from gyms? That's what the stats say. So if you're going to do this and you're going to go through the court process, know that you need to be very specific. Have court cases that you can reference. Have medical studies that you can reference. Have things that point to the absolute truth, and the government will be put into a position where they're forced to prove they're justified. Now, if we're not doing that en masse, they don't have to. So I think what's going on right now is the fines that are coming for peaceful assemblies, shutting things down. All the court cases, from my understanding, our courts are backlogged to begin with. From our talk with Mark Friesen, it was March, right?
For his, yeah.
For his. So, for instance, Mark Friesen got fined $2,800, and they gave him a court date for March. So if he's going to go challenge that, this is kind of, in my mind, what they're doing is it's going to take all this time. And in the meantime, while you're not able to get your court date, they're going to keep threatening fines. This is kind of what's going on, but it doesn't mean we don't start the process. And now I think the process needs to be begun with multiple people reaching out to lawyers and crowdfunding these things. And just going, you call ahead. This is the court case I want to bring. It's keep it simple. Pick one, or it's something that you know you can prove based on data, based on court cases. Like the mask thing for me is one that definitely could be challenged based, I think, on the precedent that was set in 2018 among many, many, many other medical studies. He's been fined 3 or 4 times now at $2,800 each. Yeah. So that's Mark Friesen's been fined multiple times. And this is what I mean. It's like bully tactics. It's meant to keep people away. And at the same time, they just keep threatening bigger and bigger fines. And then they put that seed in the back of your mind. Well, like, what if I don't win? And the reality is, sit down, look at the Oakes proportionality test. Look at our article today. It gives a textbook definition, literally, out of a brief introduction to Canadian law. That's the book, or textbook, John Fairley and Philip Swarden. It's direct quoted in there. And you can read through that and start the process. Start going, does it meet the proportionality test? What parts of it? And law's super specific, so make sure you're very specific. Have court references, court case references, have medical study references. Look at the legislation. It needs to be justified that what they're outlining is proportional, makes sense, it's rational. And it's all there. Again, so important social objectives, they'll say pressing of substantial concern. Try to make them prove every part. This is where you could talk about potentially, again, not legal advice, just opinion, but potentially talk about things like Our hospitals have been consistently overwhelmed for years now. It's been an ongoing issue. How much, freedom of information requests, what's the difference in overwhelmed hospitals compared to a normal flu season? Have those numbers, and those are the type of things that would help you on your way. I believe, again, opinion, not legally trained. Proportionality, it needs to be found to be reasonable and a fair way to achieve its legislative objective. If the legislative objective is to prevent or slow the spread, then how does it make sense that Walmart can open? Meanwhile, small businesses that are limiting the number of people coming in can't. How does it make sense that when you're a gym and not many cases are coming from gyms, that you're being told you can't do that? And again, on, like, for instance, the masking thing, we have the Wuhan study that over 9 million people, roughly 10 million people were tested, and only 300 were asymptomatic. And when they sent those 300 asymptomatic positive cases off to see if they could infect another cell culture, 0 were actually infective. So that means, is it really a justified legislative measure to force a mask on everyone? And you could argue it creates a toxic environment because of the miseducation around it, things like that. Again, opinion. But if there are 0 asymptomatic cases and you're genuinely healthy, then is it a fair thing when it's not even proven to be helpful through scientific study and method? There's also medical studies. We've written past articles. In operating rooms, they call it medical dogma, and basically say, not a lot of benefit, but also not a lot of proof that it doesn't benefit. So it's basically up in the air, but they're also talking about short periods of time. So I think, again, we need to have multiple people challenging these things. Think about it, crowdfund it, and we will get behind you if you got it on the roll and you're genuine about it, you're serious about it, and you're going to take those steps. We will find ways to help bring attention to your story as much as we can as a small outlet. So that's Greg Staley from Diverge Media signing off today. We're going to take a quick look through comments here. Hallway healthcare for years doesn't help. Take months to get a nursing home for your loved ones, so they're kept in the hospital. Exactly. So I'm going to pull up that Sweden article because I have the CBC stuff in there, and I want to touch on that a little bit more on the overrun hospitals, because it's not a new thing, and more so than I think people would actually care to think. I'm going to pull up the data. I don't want to say anything that's not correct. Just a second here, everyone. Okay, so this is okay, and pop back into this article. Here we go. So I did what's life really like in no lockdown Sweden, but at the bottom of this article, I go through personal thoughts. This is direct quotes from the CBC article. The system has been ignored and neglected for decades, says province minister for long-term care. So that's on long-term care. The scientific evidence around the effectiveness, that's not what I'm looking for. Where is it? Is it this article? That might be the other one. Sorry. Back here. It might be... Yeah, I think it's this one. What if we tested for influenza like we did COVID? Da-da-da-da. Okay. Yeah, there we go. So here's a quote from the article. Overcrowding has become so common in Ontario hospitals that patient beds are now placed in hallways and conference rooms, not only at times of peak demand, but routinely, day after day. Now, this is from January 2020. So right before COVID happened. So I think this would be relevant if you're going to talk about on a freedom of information request. It might be something I reach out for. But again, if you're going to court, they have to provide that data in a more time efficient manner than a general FOI. And that's my understanding. But Ontario's most overcrowded hospitals, not surprisingly, seem to be from the Toronto area. So Richmond Hill, Peterborough, Greater Niagara, Hamilton, South Lake, Ajax, Oshawa, Guelph. So this is days over 100% capacity, January to June of 2019 that they did the study. And there's 181 days total, but like 179 days from Richmond, 167 from Ajax, 148 from Guelph General. Now, what gets more interesting, they continue. 83 hospitals were beyond 100% capacity for more than 30 days. 39 hospitals hit 120% capacity or higher for at least one day, and 40 hospitals averaged 100% capacity or higher. So, an expert on hospital administration calls the figures astonishing, says they can that they demonstrate that overcrowding is now a widespread phenomenon around Ontario. Oak's proportionality test, is it reasonable? Well, if we can't prove that it's any worse than a normal year, you might have a case there. So I'm just trying to lay out all the different things that you might need to consider. Again, not legal advice, just opinion. But these are the things that need to be challenged. And again, putting all your eggs in one basket is not the way to do it. The more people that do this, the more challenges that can come forward, the quicker this can unravel. We have Quebecers coming here to our hospitals here in Cornwall and Alexandria. That is interesting. Again, I don't know what the hospital capacity, these are the real questions you need to ask. Even when you go to court, they just postpone it months at a time. You got that right. You got that right. So this is kind of the limbo we're in, is they've taken these measures. Your rights are being violated. That's okay so far because they've gone through the proper channels, and you need to go through the court process to prove they're not justified. But in the meantime, you don't have your rights, and it's a delayed system. And we're talking, you're waiting. Well, you could be losing your business. You could be having all sorts of mental health problems that come from a result of these measures, and yet you got to wait around months to be able to challenge it in the court. Their hospitals are worse than ours. So that's the thing. If we're going to have a real talk about this Oak's proportionality test, they like to say our hospitals are overwhelmed. That's why we're doing it. Well, if that's the case, Your Honor, you might say, is why didn't they do this? If you find out that it's been the same like this for a decade, well, why didn't they do this in 2019, 2018, 2017, 2016, 2015? Get that freedom of information request, ask the questions. So be very specific, reference court cases, but I really hope that we begin to see people challenge these and not wait around anymore. Again, it's going to take months to get in anyways, but if you're going to crowdfund it, we'll find a way to try to promote it. And we're seriously looking at potentially being the ones ourselves. I don't know what goes into it. I'm still looking into it. But I will support anyone who puts their hat forward to go about this. Businesses will be bankrupt by the time they get to court to fight being locked down. That's my concern. So the more people that, again, we have these remedies, we can try to get them through. I'm trying to think of different things that can be done. That would, yes, it's going to be delayed, but at least go through the process, get it started, and that's probably the best way to go from there. If you speak up, I think you'd be surprised at the people that will stand behind you. For instance, we shared a video from the United States, Bread and Barley, that the owner blocked in the health inspector's vehicle after being shut down and said, what am I supposed to do? I can't pay my workers, can't pay my staff. What am I supposed to pay them with? We're all in this together. These are the type of things business owners are dealing with. And I think people will support the people that stand up, because if you can help set a precedent, you're going to help many, many, many others down the road. Charmaine, they're violating our rights based on a faulty PCR test that's creating a case-demic as opposed to a pandemic. Absolutely. So we put out our template the other day. You can check out our video, or you can just go to our Facebook page and find it there, or on the website, divergemedia.ca, where we put out a template asking for all asymptomatic, symptomatic cases to be tested to prove they're actually infectious. Now, I'm going to go and update it on the request of a few people and have only hospitalized and COVID cases that died from or were hospitalized from COVID, not with COVID, included in the case count, so we can stop and have a fair assessment and not have a arbitrary or inflated number, because you can't make informed decisions if you have an inflated or arbitrary number. So businesses will be banged. Their hospitals are worse than ours. Any comments you want to bring up, Kate? All right. If that's everything for today, if we have no further questions, I thank you for tuning in. Greg Staley from Diverge Media. Share this one out. Talks about the Oak proportionality test. We'll make sure we share the article in the link. Again, I know it's not a perfect solution, and it's going to be a delayed process, but it doesn't hurt to start the process now. I wish the rule followers realized the government had no intention of giving back any rights they've taken. On that topic, many people don't think, I said from the beginning of this, I got out of the military because I said, I don't see this getting better, because if you study history, you know that governments don't just willingly give up power that they've gained. I I would like to think my politicians have only great intentions, but they're also human, and absolute power corrupts absolutely. And I believe that absolutely. So, you know, like I've said many times, we can't just think that we can just flip the switch back onto the economy and it's going to be all right. We need to stand now. And I'm not going to take 2021 lying down. So I'm going to be very vocal about it. I'm going to go out later this week, hand off the templates with my name signed to my MP and my MPP. We'll do a video on that as well. If I can even get in the door, we'll see how that shakes out. But this is what's, in my opinion, this is one of the things that can be done. It needs to be done. And we can't wait around anymore on a small group of people hoping that they'll do it. More eggs in the justice basket gives more opportunities for the win. All right, everyone. Greg Staley from Diverge Media. Thank you for tuning in. Make sure to share this out. If you're not subscribed, make sure you subscribe. And we'll see you next time. We're going to be on tomorrow night, Thursday, 8:30 p.m. Eastern. Thank you.